I'm Steve Huffner. It's my privilege to be the moderator on our third panel of this symposium. We hope we each had a pleasant lunch and are energized and ready for the second half of our terrific set of presentations today. Again, I'm not going to introduce in much depth the panelists whose bios are in your program, but I do want to say just a couple of things about this panel and the panelists. This panel has as its topic the history and future of voting rules. And your program indicates that Ellen Katz and Eric Engstrom will be presenting, and their bios are in your program. Unfortunately, Alex Keesar is not able to be with us. And of course, that's a great loss given the work he's done about the history of voting rules in the United States. But we're fortunate that we already had with us here in Columbus Eric's co-author, Jason Roberts, and he's agreed to also be part of our discussion today. And so I do just want to say a little bit about Jason, since his bio is not in your program. Jason is an associate professor of political science at the University of North Carolina, where he focuses on political parties and Congress and political institutions. He received his PhD from Washington University in St. Louis, and prior to joining the faculty at UNC, he also had taught at the University of Minnesota. I also want to just note another connection that Jason brings to our panel today. Many of the other panelists participating know that political scientist John Aldrich provided some of the inspiration for this theme. At the American Political Science Association meeting a year ago, he delivered the presidential address in which he was talking about a historical way of understanding important aspects of the American democratic process. And of course, my colleague Ned Foley has been engaged in a comparable activity in thinking about the history of disputed elections. And those things kind of came together as we contemplated with the journal editors what we might address in this symposium. And so John Aldrich has been something of an inspiration. I invite you, if you have the inclination, to track down that presidential address from the American Political Science Association meeting. I think it would be easy to find, just looking for John Aldrich and apps of presidential address. But back to John Roberts. John Roberts co-teaches, back to Jason Roberts. Jason co-teaches a course that is sort of cross-enrollment course between Duke and UNC down there in the Tri-City region. And so we are really privileged that we can include Jason on our panel today. We will ask Eric to present the paper that he and Jason have been working on. And then we will invite Ellen to present her paper. And then we'll let Jason maybe have the first opportunity to begin our discussion and have a little more time for both Ellen and Eric to also discuss each other's work before we throw it open to each of you. But we do hope and we'll do all we can to protect opportunities for you to participate in the discussion and the questions in a few more minutes. So with that, Eric.
Thank you very much. And as Steve said, this is very much joint work that I'm doing with Jason Roberts, and so we contribute to this project co-equally. And this is part of a larger effort that we're engaged in to examine the history of election laws over the course of the late 19th and 20th century. And one of the themes of our work, and it's also a theme, I think, of the other panelists today, is that election laws in the United States are very much designed by the states. This is certainly true in the context of congressional elections. And so our federal system places the power for designing democracy very much in the hands of state legislatures. And so we're interested in studying how and when state legislatures decide to reform or revise their election laws and for what purposes. And we're going to focus on one particular aspect of state-level election law, and that's the design and format of electoral ballots. States since the late 19th, early 20th century have been responsible for designing the basic format of the ballot. Now, of course, there's lots of further decentralization at the county level when it comes to ballot design, but the basic parameters of the structure of the ballot are designed by state legislatures. So I'm going to start, so the theme of this conference is the past and future of voting rules. I'm going to do both of those, but I want to start in the present. And so in the wake of the Shelby County Supreme Court decision, a number of states changed their election laws, and one of those states is North Carolina. And the primary thing that drew attention to North Carolina was the imposition of a voter identification law and the elimination of late registration, or making it harder to register as you got closer to election day. Another feature of that, of the change that the Republican legislature made in 2013, which has been less remarked upon, is they also eliminated the straight ticket provision from the North Carolina ballot. So under the previous law, voters, if they wanted to, could vote a straight party ticket by just making a single mark. So if you wanted to vote a straight Democratic ticket, you could just make a mark in the straight ticket provision or for the Republican Party, and then you would be essentially voting a straight ticket for all Democratic candidates for all offices or all Republican candidates, depending on your preference. So why would the Republican legislature in North Carolina want to eliminate the straight ticket provision? Well, this graphic suggests one reason why they might want to do that. So this is data from North Carolina counties. And one of the nice things about North Carolina is they have incredible data. And so they've collected information on the percentage of voters in each county that used the straight ticket option. And so on the x-axis here, we put the percent African American population that resides in the county, and then on the y-axis is the percent of voters in those counties that use the straight ticket. And as you can see, there's a clear linear relationship between percent African American in the county and straight ticket voting. And in North Carolina in 2012, 93% of African American voters voted Democratic. So here you can see a partisan logic behind why Republican legislators, state legislators, might want to detach themselves from the top of the ticket. And so I'm going to come back to North Carolina in a minute. But this motivates, I think helps motivate our study. And this is a reminder again that state legislatures are responsible for designing how voters experience elections and democracy. What I'm going to turn to now, though, is to go back in time a little bit. And so Jason and I are also very interested in American political history. I think following on the themes of John Aldrich's address at the APSA, our interest in political history is twofold. One, there's lots of precedent for the kinds of actions that we're seeing here in North Carolina. I'm going to show you some data on Maryland in the early 20th century, which looks a lot like North Carolina today. So political history provides us with precedent to say that current events have happened before. We've seen again that in other papers today. Also, we're political scientists, we're not legal scholars, and so we, as social scientists, look for institutional variation. And so using political history gives us a larger time frame to examine the conditions under which politicians will try to manipulate election laws and what those consequences might be. And so as I said, we're looking at state-level ballot rules, and the rules that for ballots that vary considerably across time and across states. So I'll just walk through a few examples here. So this is now we're going to go back into the past. This is a ballot from the 1876 presidential election. This is the Republican ballot from Massachusetts. So this is Rutherford Hayes on there, this vice presidential candidate. And so in the 19th century, the way voters cast ballots was ballots were not printed by the state government, they were printed by the parties. So there was a Republican ballot, the Republican Party would print up its own ballot, and the Democratic Party would print up its own ballot. And then you would have the presidential candidate or presidential years at the top of the ticket, followed by various offices as you work your way down the ballot. One thing to note about this is a Republican ballot. As you can see, there are no Democratic candidates on this. So in effect, voters were voting a straight ticket by default. You either voted a Republican ticket or a Democratic ticket. There's some occasions where you could try and write in different candidates, but for the most part, voters were voting one of these straight party tickets. This was also done, just to note, in public. So this is before secret balloting, and so party workers can watch you drop your party ticket into the ballot box, which helps explain the high levels of turnout in the 19th century and other facets of 19th century electoral politics. I'm not going to spend too much time talking about this particular format. What I want to then talk about now is the reform movement that happened in the late 19th, early 20th century, in which this kind of balloting was replaced with state-supplied ballots in which candidates of all parties were listed on the ballot, and voting was done in secret. And as Kareem mentioned earlier this morning, that the waves of reform are usually only the first step. And so there was a wave of reform in the late 19th, early 20th century, which I'm happy to talk about later if you want. But the movement to a secret state-supplied ballot didn't end the story. States continued to tinker with their ballots after the switch to the secret ballot, or Australian ballot, as it came to be known. And states continue to vary in the kinds of ballots they use. And so here I'm just going to give you a couple of the standard archetypes. The first is an office block ballot, where candidates are listed office by office. So you'll get a ballot, and in this case this is the Alaska ballot in 2006. We like this one because it had Sarah Palin on it. And so you have all party candidates for U.S. representatives at the top, then the governor, lieutenant governor, and so on. So this ballot requires voters to go through and make office-by-office choices for candidates. The second archetype, and this one didn't come out so well, so I'll turn to this, is a party column ballot, where candidates are listed in party columns. So all Republicans will be in one column, Democrats will be in the next column. And often the party column ballots will also have a straight ticket provision. So you can see that circle up on the top there. That would allow you, if you just put an X there or a mark, that would indicate that you're voting the straight party ticket. So you wouldn't need to go further down the ballot and make office by office choices. You could if you wanted to, but you didn't have to. And this is from the 1908 presidential election in New York State, which we'll feature in a minute. So those are kind of the two archetypes, the office block and the party column ballot, and then some states would add the straight ticket provision, usually on the party column ballot. And so we've collected data on state-level legislation related to ballot laws from 1888 to 2008. I'll just highlight a few trends here. The dashed line are party column states, the office block are the solid lines, and so on the y-axis is the number of states using one format or another. So for most of the 20th century, at least until the mid-1960s, the majority of states were using, or plurality of states were using the party column ballot, which in some ways makes sense. You have the old party machines attempting to maintain some control over the electorate, and so the party column ballot gives them more control over voting. And then there's been an uptick in the use of the office block ballot beginning in the 1960s, and then a sharp uptick in the 2000s, which we think is probably a consequence of the Help America Vote Act. It's hard to fit an office block, a party column ballot to a computer screen. So we've seen that uptick there. What I want to focus on now, though, is kind of the early part of the 20th century. As you get that first wave of reform, states continued to tinker, especially in the years between 1890 and 1920, with the format they use, and as we'll see, for very partisan purposes, I think. So what would be the logic behind choosing one versus another if you're a politician in a state legislature? Research that suggests that the party column ballot, where you're lining up candidates in these straight lines, promotes straight ticket voting, especially if you have a straight ticket option. It minimizes ballot roll-off, so voters who voting for the president are also voting for all the other offices down ballot. It also encourages mobilization efforts by the parties to turn out voters. If you bring a Democrat to the poll and you know they're going to vote a straight ticket, that's good for the party. If you bring a Democrat to the poll and they're splitting their ticket, that's in some sense wasted effort. So knowing that you get a high straight ticket voting under the party column encourages mobilization efforts by the parties. On the flip side, the office block promotes split ticket voting. It increases roll-off, so voters, especially on longer ballots, will just stop voting at some point, and also discourages mobilization, discourages turnout. And these effects are especially pronounced amongst weak partisans and independents. So kind of knowing that these disparate effects, we would expect that strategic politicians would take this into account in designing their ballots. We're still working on kind of matching changes in state election laws to partisan composition of state legislatures. So what I'm going to show now are just two examples where we have good narrative political history to complement the data. So the first example comes from Maryland. So as I mentioned earlier, Maryland initially, when they adopted the secret ballot, chose the party column format. They switched to an office block ballot in 1901. It was a Democratic-controlled legislature with a Democratic governor. This was part of a broader effort in Maryland to depress the African American vote, which leaned heavily Republican in the early 1900s. Moreover, the party column ballot did not work to the benefit of Democratic candidates lower down on the ticket. We have various quotes, particularly from the Democratic state party boss at the time, Arthur Gorman, who was upset and complaining about the Democratic Party nominating William Jennings Bryan 2 times in a row. And campaign oriented around agrarian populism was not playing well in Baltimore. And the Maryland Democrats lost all their House races in 1900. And so Gorman said, we got to do something about this. So they switched to the office block ballot with the idea that down ballot candidates, Democratic candidates, would be able to withstand the adverse tides that you were getting at the top of the ticket. So did it work? Yes. So this is roll-off. So this is the percentage of voters voting in the presidential race minus the percentage of voters voting in the congressional race. And so as you can see on the left side here, with the party column and the straight ticket provision, there's very little roll-off. Voters are voting for all the candidates or for all offices. As you introduce the office block, there's a sharp uptick in ballot roll-off. You see a similar effect when you look at turnout. Turnout following the switch drops off quite dramatically. And it's not just a function of elections becoming less competitive. The 1904 presidential election in Maryland, as far as I can tell, it's the closest race I've ever seen in a presidential race. Teddy Roosevelt won Maryland by 51 votes. So this is 51. Nevertheless, turnout drops off sharply and then continues to drop off after that. Just another story here is from New York State, where you have a Democratic legislature in 1913. They had lost power in the lower house, and right before they're about to leave office, they switched ballot formats, which tells you something must be up with that. And so you have Democrats here switching to the office block ballot, largely to insulate themselves against Republican candidates at the top of the ticket. Teddy Roosevelt, for example, at the top of the ticket in 1912. Did it work in New York? Again, yes. So roll-off increases with the switch in New York. It's most dramatic, almost immediately in the 1916 presidential election. I'll just show one other state. So the two states I've shown so far have gone from the party column to the office block. So you might think, well, maybe there's kind of a time trend. It's just increasing roll-off over time. So California figures nicely because they switch back and forth between formats. This is the Republican Party the whole time, kind of switching back and forth. So when you have the office block ballot, roll-off goes up. When you have the party column ballot, roll-off goes down. They switch back to the office block, roll-off goes up. And so below the presidential level, people voting in congressional elections are, the pool of voters are fluctuating up and down depending on the simple format of the ballot. I'm going to skip over the statistics part. So I'm going to jump to the future since I'm running out of time. So that was the past, what's the future? So I'm going to return here to North Carolina. As I said, North Carolina removed the straight ticket option in 2013. So we don't have a comparable presidential election yet to compare as kind of a before and after examination. But if we look at 2010 and 2014 as our comparison, we had a Senate race at the top of the ticket in both of those years. What's the roll-off from the Senate race to the state assembly? In 2010, it was 11.5%. You remove the straight ticket option, roll-off increases to 17.8%, which is a 54% increase. In 2012, the presidential election roll-off was about 16.3%. So if you were to assume that a 54% increase would apply in 2016, it would suggest about a 25% roll-off for state assembly. And if we go back to that first figure that I showed you, the roll-off is not going to be a random sample of voters. You would expect it to be concentrated amongst Democratic voters, particularly in counties with large African American populations. So the general conclusion that we want to make with this example of ballot rules is that how voters experience democracy, the makeup and pool of the electorate is fundamentally shaped by party competition in the states. And so party competition and the jockeying back and forth between parties dramatically affects how elections are conducted and who might win or lose. And I will conclude that.
It's great to be here. Thanks for having me. I want to thank Ned and Steve for putting together, including me in this event, and to Mandy and the Law Review staff for really a superbly organized event. I drove in this morning, Mandy sending me emails, are you okay when you get here? So I feel very, very well cared for. My as a jumping off point to think about future paths that voting rules, voting rights law might take going forward. And I want to focus on language from two decisions from the Supreme Court from last June, neither of which are voting cases, but from which I think we can take some, see some templates or some encouragement for productive ways that voting rights law might develop in the years to come. In characterizing these as templates or even as encouraging signs, I do so with some caution. I'm mindful that it was almost a decade ago that many of us gathered here in Ohio for a conference much like this one. I was among a group of people who saw some promise in the Supreme Court's decision in Luloff versus Perry, which was a new decision at the time. That didn't work out the way I at least thought good things might have come. So I speak or offer these thoughts as possibilities, but certainly not as predictions. I'm not doing that anymore. So the first case I want to talk about is called Texas Department of Housing and Community Affairs versus the Inclusive Communities Project. Some of you know about this case. This is when the ICP, this organization, challenged the manner in which the state of Texas was awarding tax credits for low-income housing. And their objection was that Texas was awarding them to inner-city African-American communities in a way that perpetuated segregation as opposed to placing more of them in white suburban communities. The question that came before the Supreme Court was not that specific question, but rather whether the Fair Housing Act, under which these provisions, the Texas's practice was challenged, whether the Fair Housing Act should be understood to prescribe practices that had racially disparate impacts, and whether that was even a cognizable claim under the Fair Housing Act. And it's worth noting that the very fact that that question was before the court at that time is a curious one, given that the Fair Housing Act was enacted in 1968 in the wake of Martin Luther King's assassination to address segregation in housing. It had been repeatedly interpreted to cover disparate impact. It was amended by Congress in 1988 in a way that made clear that Congress thought it covered disparate impact. And yet the Supreme Court took the case, not once, not twice, but in fact 3 times to address the question. The first 2 times the case is settled, in large part because folks who think disparate impact under the Fair Housing Act is a good thing were concerned that the justices were taking the case to get rid of disparate impact under the statute. The Texas case does not settle. It goes to merits, and in a 5-4 decision written by Justice Kennedy, disparate impact survives. It comes out a little damaged, but it does survive, and that's good news as far as that goes. For present purposes, though, my interest in the case, the reason I bring it up here in a voting conference, has to do with something Justice Kennedy said in the closing paragraphs of the decision. So after he walked through the sort of types of arguments you would expect, arguments about text, precedent, legislative history, policy, at the end of the opinion he comes to reliance. And by reliance among residents, among policymakers. And he cites a brief cited by submitted by the state of Massachusetts and quotes it. And I'll give you the language. Without disparate impact claims, states and others will be left with fewer crucial tools to combat the kinds of systemic discrimination the FHA was intended to address. Justice Kennedy also went on to say that many of our nation's largest cities, entities that are potential defendants in disparate impact suits, have submitted an amicus brief, in this case supporting disparate impact liability under the FHA. He cites a brief filed by the city of San Francisco and a number of other cities. So what's noteworthy about this? And to my mind, it's actually quite noteworthy. The fact that state and local officials, the potential defendants in these lawsuits, didn't find the prospect of liability burdensome and actually thought it was useful to be regulated by federal law in this way was seen by the court as a good thing. It was another reason to sustain a finding of disparate impact under the Fair Housing Act. And that's actually something new. For a number of years, I've been working on a paper that never gets off my laptop because I never quite know what to do with it, but I've been collecting examples in which state and local officials have come before the court or otherwise voiced support for federal civil rights law and said, we like this, interpret the statute broadly. And time again, when they make that claim, they are viewed with deep skepticism and sometimes hostility from the court and from specific members. I can give you, I don't want to bore you with a whole bunch of examples, but I'll just give a couple. So Bartlett versus Strickland in North Carolina case, when North Carolina was saying we can't enforce our Constitution because the Voting Rights Act won't let us do this, Justice Kennedy, in a decision that rejects their claims, says this case is kind of an unusual posture given what North Carolina was arguing. In the history of the Voting Rights Act, we see, particularly in the last reauthorization, time and again, the support given by formally covered jurisdictions, the failure of covered jurisdictions to take advantage of bailout procedures being met with skepticism by the court. Why don't you want out from this federal regulation? When the city of New Haven threw out a firefighter's promotion test, said Title VII won't let us use the results of this test. The court again viewed that action with skepticism. And if you go even further back in time and look at school desegregation cases, the city of in Kansas City, Missouri, or way back in the 70s when Detroit was resisting being set free or released from school desegregation orders and said, keep us regulated. When they make these claims, courts time and again view it with skepticism. These are very different examples, but I cite them because I think they do show a sense that resistance is the appropriate stance for state and local governments when it comes to federal anti-discrimination law. You don't quite have to be George Wallace and opposing federal law in that way, but grudging compliance is kind of what we expect, or a little bit of bristling about requirements. When they come in and say, bring it on, we want this regulation, it's met with what's going on here, skepticism, cynicism, and at times a view that there's something dysfunctional going on at the local level. And you see that, I think, in Justice Alito's opinion in the Ritchie versus Stefano decision in particular, but go back to Milliken versus Bradley and the opposition, the notion that Detroit was dysfunctional because it wanted to retain federal supervision. So with that history of where we go, I think there's something quite interesting in Justice Kennedy's reliance on briefs cited by state and local governments, and the notion that they conceive of federal anti-discrimination law, the Fair Housing Act in particular, as a useful tool. And the fact that they view it as useful, crucial, counts in favor of the provision, I think is a productive step forward and a way that understands or reflects a more sophisticated understanding of the way racial discrimination finds expression today, where you have many different actors, state actors, many of whom are acting in good faith, maybe all of them are acting in good faith, and yet policies can be developed that devolve to the detriment of particular communities. And the recognition that federal anti-discrimination law, Fair Housing Act, yes, the Voting Rights Act, might be vehicles to help local officials making decisions in these contexts, I think is a promising development, and possibly one that might reflect, as we go forward, cases under the Voting Rights Act, the provisions that remain, the voter ID provisions that are being challenged now, a notion that looking at the way these practices might violate federal law would help to achieve a more productive result. And again, I don't anticipate state and local governments necessarily supporting the application of Section 2 of the Voting Rights Act in these contexts, but at a minimum, a sense that their support in the past for them ought not to weigh against the validity or usefulness of the provisions going forward. The second point, or the second data point I want to focus on, is also from a decision from last term, also a Justice Kennedy opinion, and also Justice Kennedy opinion that does involve voting rights. And that's the marriage equality cases of Blumenfeld, which I called the Gore because in Michigan that's what we called it. I want to focus on the point I mentioned or discussed with some of the people in this room previously, and that specifically is the role that dignity is playing in the marriage equality cases, and the prospect that that idea might gain traction in the voting context. So in a nutshell, the same-sex marriage cases brought to bear or brought to prominence this notion of dignity, and same-sex marriage bans are now understood as to have inflicted a dignitary harm on same-sex couples by denying them the ability to participate in marriage as opposite-sex couples do as a matter of course, and this idea pervaded the cases on marriage from Windsor through the decision last June, and the injury that's understood is to stem not from the denial of tangible benefits of marriage, which could be obtained through civil union or domestic partnership arrangements, but the right or the ability to publicly solemnize, to use the Sixth Circuit's language, their relationship in a way that opposite sex couples are allowed to do. So I think there's a crude analogy that we can draw, that the notion that certain types of contemporary regulation of the political process, the electoral process, impose a burden that should sound in dignity to voters. Voter ID, the cutback on early voting in Ohio and how that has come to bear on certain communities that have taken advantage of it, other restrictions of this sort, and just to focus on voter ID. To scrounge up a birth certificate, make repeated trips to various municipal offices, take time off from work, secure transportation, pay consequential fees. To do all of these things, we presently talk about that. Well, were you able to vote or not? And if you were able to vote, no harm, don't worry about it. And I think it would be useful to think, well, maybe there's damage done to the way people are traversing the political process, the electoral process, even if they ultimately manage to cast a ballot on election day. And the idea of dignity is a place that is an idea that we could use to think about that. And what I find curious in thinking about this question is the absence of dignity in discussions about voting rights and election law generally. You don't see it as a legal term or a legal argument in voting cases, even among folks who I think would be sympathetic to it. And it's curious. It's curious to me for a variety of reasons. The idea of dignity might be something that makes some of us cringe a little because of its malleability, because of its association with Justice Kennedy's form of jurisprudence, which sometimes feels a little, I don't know what word to use there, but less than fully satisfactory, and so it's malleable and it's troubling in that way, and yet dignity is doing real work in various areas of the law, certainly in the same-sex marriage context, but elsewhere as well. And it invites us to think about why it's not doing work in the voting context. It's also curious to me because at the level of theory, if you want to go top down on this and think about what is dignity, what does it mean, we have book after book that's been written about it now, articles that parse 3 different typologies of dignity, various lectures, conferences that one can invoke to look at a definition, and very many of these definitions, it's quite easy to plug voting in and say, you know what, that implicates dignity, and some leading scholars on the subject, in fact, do it for us. Judith Schlarb did it very famously. Jeremy Waldron's work about the notion of the upward equalization of rank, and that dignity implicates that, is, I think, a place where you can understand voting to fit in quite easily. But the part of the absence of dignity from contemporary discussions about voting that I find most telling, I'm going to call this a project that I've been working on, I'll say more from a bottom-up type analysis. The idea of dignity pervades every debate about voting that we've seen, and I thought Alice Keysor was going to be here. You look at this book, which is such a marvelous book, and it's the gift that keeps giving. You read it again and again, and keep finding new things in it every time I go back to it. But you look at the debates, the way folks who have fought for voting rights, before the 15th Amendment, for the 19th Amendment, in challenges to Jim Crow, they talk about voting as not simply an instrumental act that allows them to influence the choice of candidates and the future policy, but as an act that is in which dignitary interests are deeply ingrained. And so I have tons of examples, and I won't bore you with them. But this is from Alex's book. Henry Ward Beecher speaks in 1865 about the need for universal mass suffrage, and he describes voting as an act that ennobles the voter, and this notion of elevation and what would happen when we vote. Frederick Douglass's speeches are full of this reference. There's clear instrumental arguments about voting is good for these reasons, but it's also something that will that implicates the dignity of the voter, and something we should be concerned about. Elizabeth Cady Stanton spoke of the new dignity voters acquire. She was speaking of immigrants and lamenting the fact that women were not given the rights that new immigrants off the boat were being given, but she talked about the new dignity these new voters would acquire. We should expand that. Susan B. Anthony, at her trial for illegal voting, said, the denial of the vote, I am degraded from the status of citizen on that subject. I also think one of the things that you see coming out of this history is the notion that voters' dignitary interests can be compromised by regulations that fall short of disenfranchisement. And so while many of the pivotal examples from history reflect I'm disenfranchised and hence my dignity is compromised, we also see during the Jim Crow era claims being made that suggest compromising the inability of African Americans in the South to participate by a process that doesn't allow them is also something that implicates dignity. I'll just give one example here that I found from a Chicago Defender article in the late 1940s, in which an African American man in Mobile, Alabama, is serving as a voucher at a time when in Mobile the idea was you couldn't register to vote unless somebody who was already registered was there to vouch for you. And his name was Napoleon Rivers, was standing there, 72-year-old man, and he was vouching for people, and Mobile was involved in a slowdown, meaning they weren't registering anybody too quickly, and he'd been standing there for hours. And at one point he asks a police officer at some point, may I sit down? And he's told no. And in fact, there's a scuffle that follows that puts him in the hospital for 10 days following that incident. And the notion that the dignity of Mr. Rivers is implicated by an incident of that sort was clear to the reporter from the Chicago Defender, who was actually urging black voters in Chicago, why are you not participating? Look at the humiliations that black voters in the South, or black citizens in the South, are enduring to try and participate. So I think this notion of dignity is there. My time is just almost up, so I wanted to sort of take a moment to think about what might change if we actually activated dignity as a real concept within voting rights law and thought about the work it could do. I think the voter ID context, the barriers that we've seen in recent years to participation, is a place where dignity would play, I think, or could play a very promising role in helping us to isolate the part of the political process that I think current law is not capturing with its focus on could you vote, were you successful, and to understand that harm might be done to poor voters and poor voters of color in particular by restrictions that put up needless obstacles to participation, even if they don't make participation wholly preclusive. I think we could actually talk about campaign finance in a useful way if we started to recognize voters as people with dignity, but I'll leave that for a moment. And I'll close with actually a thought of a case that many people in this room have worked on, and that's the Evenwell one person, one vote, one voter, one vote case that's pending before the Supreme Court right now. And this is this case out of Texas, and I know about this. Let me just say the following about it. The concern in the case is that the court will rule and say that one voter means one voter, and so we will reapportion districts to shift power from districts with large non-citizen populations. And I think there's lots of reason to be concerned about this case, and in part I think the preservation of the status quo, which many people are advocating for to leave this to state discretion, is not ultimately a preservation of the status quo, because once it were the Supreme Court to rule that states have discretion on this ground, we're going to see states exercising that discretion in a way they have not done previously once it becomes clear that they could in fact redistrict in this manner. But what I want to close with is the thought that dignity might help us to think about an element of the case that's presently missing, which is if non-citizens are counting for purposes of apportionment to increase the size of state delegations, if non-citizens who reside in places help the state of Texas get a much larger congressional delegation than they otherwise would have, to then exclude them from the count of who lives in any given district gives rise to an injury, or might be understood to give rise to an injury, that offends the dignity of those non-voting residents, of those persons, to be used instrumentally to elevate or to increase your state's delegation and then not to count, is something we should be thinking about and be weighing against the interests of the voters who have brought this suit, who claim that they are damaged and harmed by the disproportionate voting power of officials, of voters in districts with more non-voting residents than where they live. So with that thought, I'll close and look forward to the discussion that follows.
discussion among the panel. I'm going to invite Jason first to just live a little bit of his own reflections on these topics. So, thanks again for doing this with us, Jason.
Well, thanks for having me. Just want to maybe start our discussion in thinking beyond what we were doing in terms of roll-off. And you know, a lot of, if you think about the North Carolina law, there are many aspects of that. In addition to the elimination of straight ticket voting, there's the well-known voter ID requirement. And I think something that people haven't thought a lot about is how that's going to lead to much longer lines at the polls in highly populated areas. In 2016, it's a huge ballot. You know, in 2014, there were only 4 essentially statewide or federal races on the ballot. It's closer to 15 in 2016. So I think we're going to see longer lines. That's going to deter some voters. North Carolina also eliminated pre-registration of people under the age of 18. It used to be something people did in their civics classes. They instituted an early closing date for voter registration. And you know, Eric lives in California. At the same time, we see California experimenting with things like automatically registering people to vote. They've expanded their pre-registration process. So I think the larger question here is how voters are experiencing, or citizens are experiencing democracy differently across states. And I think perhaps post-Shelby County, we're going to see much wider variance in the way people are going to be experiencing the voting process. So a question for thought is should we think about this as something that could be handled nationally? I mean, clearly, Congress has the power to set national voting standards if they so choose to. Whether they will or not is an open question. But I guess a question I would have for the legal community here is at what point could this be considered an equal protection type issue? That my right to vote in North Carolina may be quite different than Eric's in California or other places. So.
Thanks, Jason. I'll interrupt my planned schedule here just to say I was having some similar thoughts, and I am interested in all of our reflections on this. Even when Eric began his presentation, I was contemplating just the tremendous variety that there has historically been and continues to be across states. And with understandable reason from a historical perspective, but at some point you have to start wondering whether we really need more uniformity. And Shelby County was giving us some of that, which, as you pointed out, Jason, we may be moving away from at this moment. At a time when there could be real value in much more uniformity for a variety of reasons. And that connects up to this idea about a dignitary basis for thinking about these very decisions and these structures. That, to the extent it took hold, would really bring some substantial unification to what states are doing. It's not necessarily clear even what they would be, but it is quite intriguing to think about the combination of each of these presentations. Let me see if Eric has anything to say in reaction to Jason or Ellen at this point.
Nothing right now.
Not right now? I may ask a question in just a sec. Ellen, did you want to say anything else before we open it up? So maybe I'll hold my questions then and we'll just go right in, and then I can throw in some questions as we go. So again, we have mics. We'll try to get them to you quickly. That will help for purposes of people who might be trying to tune into our Twitter feed. So Bethany, I see you're ready to go.
Thanks, Professor. This is primarily for Ellen, but anyone on the panel. I am very interested by this idea of trying to incorporate dignity into the analysis of looking at voting rules. I work in policy and politics in Ohio, and I wonder how those who are working on these issues, be it legislatively or interpretation, could or should lay the groundwork for the inclusion of a dignity analysis in the nearly inevitable litigation that follows on changes.
So it's a great question. I mean, and I do think it's curious when you look at briefs, given how prominent the idea is in discourse. President Bush reauthorized the voting rights, signs the reauthorization in 2006, and he speaks of the dignity of all citizens and of all voters, that is, that the Voting Rights Act preserves. And Lyndon Johnson, in his famous speech giving rise to the Voting Rights Act, speaks of dignity. I mean, it's the sort of way we understand it, and yet you don't see it in legal argument. And I said I wasn't going to engage in prediction. Yet Justice Kennedy's going to decide this stuff, and he likes this idea. So maybe let's be predictive and give him something to hold on to. I think it's curious. And I've been to a bunch of these voting conferences where folks talk about the cutback in early voting in Ohio in particular, and the use of early voting by the African American community here with, the Souls to the Polls initiative. And folks say things like, I've heard this from very reasonable people, say, well, all these other states don't have early voting, so how can Ohio run into any trouble by cutting it back? And I think there's something to be said and to think about the context in which these moves are made, and that it's possible for states to have tremendous variation in their practices, and simply because you implement a practice doesn't mean you can never go back from it. But when you see the kind of participation and the meaningful community-based participation that we saw in Ohio through Black churches, and you take that away, well, that has a different significance. And I would say sounds not just in racial discrimination, which I'm happy to go there and make that argument, but also it sounds in something that's not adequately, sufficiently attentive to the dignitary interests of the folks who were making use of that process. So put it in your brief and see what happens. Then blame me.
So this is on the same question. I agree that the concept of dignity is promising, Ellen. And just to comment, we've actually seen it in the not too distant past. Remember Bush versus Gore talked about equal weight to each vote, equal dignity to each voter, in an opinion that was per curiam, but probably written, and I suspect that line written by Justice Kennedy.
So I'm reluctant to run with that as the basis for it. And so yes, in all fairness, when I started thinking about this project and thinking about the role dignity plays, I was like, dignity plays no role in voting law, which is not quite right. So Bush versus Gore is obviously an example. Some people have said that it's actually implicit in the voter ID cases, not in defense of the folks who don't have ID, but that it's implicit in this claim about voters who do, and how, and Alex has actually written about this quite powerfully, how my legitimate vote is being outweighed by all you fraudulent people out there, and I'm harmed because of that, that there's something to that sounds in dignity of the legitimate voter. And obviously the Shaw versus Reno cases, while they don't use that language, the way in which the court objects to racial gerrymandering sounds in dignity. And I think the problem there, I was say this succinctly, that dignity, to the extent dignity's played a role in voting cases to date, it has largely been, Bush versus Gore maybe the exception, to limit the role of the voter. It's around the edges, it's saying there are these other values, and I think that might be part of the reason why folks who would be inclined to press dignity claims don't want to do it, because they don't like the context in which there has been some overtures towards dignity. And I would say, like, get over it. It's a thing, and let's use it for good as well as for limiting right.
Would dignity apply to the questions as well as the long waits in line? 3 to 7 hours in the Columbus majority and heavily influenced Black districts versus 15 minutes in suburban areas. And also, right, if there's a county with 10,000 votes, 10,000 voters or 10,000 people versus one with over 1 million, and you assume there's one place to early vote, and you go down to Cincinnati or Cleveland and there's 5 and 6 hour lines. I mean, to me, and you're standing in a cold rain as they were in 04, isn't that a question of dignity as well?
So, great question, and I've been thinking about lines, because I think there's two different, I think definitely long lines is something we should be thinking about, particularly long lines in some places and not others, and I think that disparity raises a question that we see that could be generalizable. The way some people experience it and the way other people experience it, the burdens that are selectively imposed on some communities, might say that there's an equality basis to this dignitary interest I'm trying to make sense of. So it matters where the line is. What if everybody is waiting a really long time? That might still be a problem. And maybe it's still a problem that sounds in dignity, but it's a little bit different than the one you just described. There's accounts in Florida, I'm sure it's elsewhere too, where people were online for a long time and were not allowed bathroom breaks, and you lose your place in line. That kind of sounds in a problem to me, that might be not treating voters with adequate respect. That said, it is contextual, because I was just talking to a law school classmate when we were in law school, it was when the first elections were held in South Africa, the non-race-based elections, and you saw these pictures of people waiting in endless lines. And it seemed like there was something about that that didn't seem undignified. It actually seemed heroic at that moment. But of course, we want to think about the context of who's waiting in line and who's not. So I think the lines are a huge thing to be thinking about, both in terms of equality, but in also just the substantive, is there an amount of time beyond which we're not treating voters with adequate respect?
You know, it is interesting to think about how many different issues might be understood in a different way if you're thinking of them in terms of dignity. I think it's also interesting to take that lens to the past history, you know, and to go back, for instance, to what Eric and Jason presented as some important examples of the way in which state legislatures, with their authority to set voting rules, had done so in ways that were partisan. And I'm sure we can find lots of examples. That's probably more than the norm. It's probably almost always what the legislatures have done, but not universally. I'm sure we can find occasions when legislatures have made choices about voting rules that weren't driven by that kind of partisan motive. But as I think about looking back at those choices made in the past, you know, thinking about the stories you were telling, Eric, in your paper, there's a way in which what's happening there is the legislatures are using the individual voters as pawns, right? And that strikes me as, in some ways, sort of just completely antithetical to the dignity of the voter. And again, that's just trying to, you know, connect up the history with the prospective way of moving forward with some of these issues. I did want to ask Eric and Jason, you know, you said when you started looking at the change that resulted where, you know, let me take Maryland as an example, where they moved from the straight ticket to the office block ballot, that in fact you see that difference in the roll-off. But you know, you made the observation that this was done because the Democrats in the down-ballot races really were worried about their position. The 1900 election had been a disaster for them. And then you observed that they made this change, and did it work? And your answer was yes, but your answer was yes because it produced a fall-off. Did you look to see what the outcome was in terms of the down-ballot races because of the fall-off?
Yeah, we've looked at the House races. I mean, the Democrats did do better in 1904. In Maryland, the state legislative elections were held off-cycle. They were held in odd years, and so they weren't on that particular ballot. But yeah, so there was some increase in success of the Democratic Party. And it wasn't an overwhelming success.
They were fighting too hard at the battle that year.
Yeah.
So let me continue to invite your questions. There's one. Gary?
Let me reinforce something about what Vegas was saying. We had a problem here that went beyond dignity, because in certain neighborhoods, you might have an ward with 20,000 people and 2 voting machines, and a ward with 1,000 people and 2 voting machines. And the people in a working class neighborhood gave up. After you've been standing in line for 6 hours, you've worked a 10-hour day, and you know you're going to have to go work the next day. Isn't there a theory beyond just dignity that applies in these kind of situations where the allocation of resources has the effect of heavily determining the outcome of a given area?
Yes, that's me. Yes, and so I mean, I think part of, I said I wasn't being predictive, and here I am. I think part of the difficulty in election law at this moment is finding tools to target that form of inequity. And it's very difficult, given the state of constitutional law, if you will, to make out an equal protection claim under those circumstances, particularly with the over, you know, the notion of state discretion to structure these things as they do, to say that this is discrimination on the basis of race, on the basis of poverty, we know is a non-starter. Every rule is going to affect people with fewer resources in a problematic way. So the fact that we vote on Tuesday is a problem. Is it unconstitutional that we vote on Tuesday? Ooh, it's going to be a rough one to pull that one off. So it's harder for people with fewer resources to get to the polls. Does that mean we must have absentee ballots on demand? We could talk about what's good policy, but to frame an argument about what is impermissible under federal law, be it the Voting Rights Act or the Constitution, is very difficult in the circumstances you just described. So that's in part, when I think about dignity, I think it's actually a way of thinking about the right to vote in what my colleague Sam Baggins has talked about, universal terms. Let's talk about what the right ought to look like, as opposed to, and Dan Takaji's written about this quite eloquently, as opposed to the parties that are affected by it. There's reason to be, you know, worried about those claims, but rising tide lifts all boats. Maybe we can think the core of voting requires certain things. It doesn't get at the claim that you're making, but I do think the burdens and this goes to the back of the previous question about the length of the lines, affects people differently, and is something we should be considering, and our present language doesn't capture it. And let me just say one other thing. If you look at the Wisconsin voter ID case that the Seventh Circuit decides last year, Judge Easterbrook, who says this voter ID measure is fine, Judge Posner is dissenting, so it's not on the same panel, but is dissenting also to give you an idea of what the dynamic is there. Well, one of the things Judge Easterbrook says is, look, these people weren't going to vote anyway, and if they're not willing to, I'm paraphrasing obviously, but it's not too far off. If they're not willing to make the effort, well, whatever, what are you complaining about? And your question, I think, goes to the notion that, well, wait a minute, people have complaints, and people who are unwilling to make the effort may in fact be unable to make the effort because of their circumstances, and it's something worth discussing and thinking about.
Voter turnout is often a determinant of the outcome of elections. And how do countries that have a large voter turnout accomplish that?
Well, one reason is compulsory voting. So a number of countries have compulsory voting. The industrial countries that have 90+% turnout, you're fined if you don't vote. So Australia would be a prominent example. So we could certainly increase turnout if there was the political will to do that. This is America, right?
It's also, I think, true that, you know, it's not quite apples to apples in the sense that countries with dramatically higher turnouts have far fewer elections, right? And there's a way in which we kind of have election overload, right? There's so many moments when we can vote and then so many races on the ballot or issues on the ballot that affects it, or at least I think there's some political science literature about that.
That's right. Yeah, campaigning politicians, I have stories from Iowa in the 19th century where they would hold elections basically every year. And so they would campaign, they'd hold an election, they'd take a bath and start campaigning the next day. So in fact, these days even more elections.
And your data was also showing higher participation rates when you had the, you know, those.
That's right. Yeah, right. So part of it was that this was again the eligible pool of eligible voters was smaller, but the party organizations were designed to grapple with having to conduct multiple elections, and so they became vote gathering machines partly for the purpose of conducting multiple elections.
I'd also say, you know, very much part of the interest that many of us in this field have is thinking about ways to make the processes work that inspire participation and confidence, and you know, that's part of why we think about these things. I know Ned had a question, and Sherry, so go ahead.
Yeah, real quick, just to follow up on that last point, Eric and Jason, I'd be curious from your perspective as political scientists and the data that you have on roll-off, whether that's any kind of counterpoint to the dignity argument, which is very interesting and worth pursuing, but I understood the roll-off point to be, you know, voting is somewhat instrumental in nature. If voters do roll off, it means they have the cognitive, they have the knowledge of the race at the top of the ticket, they pay attention to that, that's what they care about, they vote that ballot, they decide voluntarily, since they have the ballot, they could have gone down the ballot, but they don't have the information about it, they decide not to participate at the lower races. From a structural perspective, we might say, well, the system is working, the voters provide the input that they want, and they get the outputs that they get. Or we might say, well, that's a concern, we aren't matching the voter knowledge level with what we want. If there's going to be self-governance in a society, roll-off is sort of the opposite of that. And all of those concerns don't sound like dignity necessarily to me. So I just would be interested in your perspective as political scientists, how you respond to adding dignity as a dimension of evaluating our system, given the data that you have.
Part of the problem is we don't really know why each individual voter decided to roll off. It could be an instance of what you're saying, that if I go to the polls, I choose the races I'm interested in, and I'm simply not interested in the others, I leave. But I think it could also be a resources factor or a cost factor, that the longer ballot, the longer lines, you simply don't have the time. You know, by the time you get to it's your turn to vote, do you really want to take all the time to go out and figure out who you're going to vote for Commissioner of Agriculture? If you live in the city, who cares? And so it's unclear how much of this is a choice to not participate, and how much of it is resource and cost driven. Because we know that people are very sensitive to the cost of voting in terms of their participation.
I think that's part of the limitation of our data. Is, we only have the behavioral outcomes, and so it's hard from our data to be able to tell what's going on in the minds of voters that might produce this behavior, whether it's the cost story or some other factor. I have to admit, I haven't thought about what Ellen is talking about until today, so still grappling with that. It's very fascinating. One, I know we're running out of time. This may not be a fair question, but I wonder how this would apply to something like the U.S. Senate, which is the most malapportioned, one of the most malapportioned legislatures in the world. As you know, I live in California, and we have 2 senators relative to Wyoming. I hadn't thought about that before.
So we're going to give Sherry the last question.
Yeah, I don't know, this may sound kind of crazy asking this, but it has relevance to the Ohio Constitution, and that is, does it make a difference if you refer to voting as a privilege or as a right in a constitutional document, as far as the dignity question and as far as what policy flows from that?
So, I mean, I think we have, I'm pausing because I'm thinking of some of these debates that I've been looking at in connection with this project, sort of 1960 debates about who gets to vote. And those debates are deeply steeped in the notion whether we're going to understand voting as a right or a privilege. And obviously, if it's a privilege, then it doesn't really work. We presently at least believe it to be a right under the U.S. Constitution, so I'm going to run with that as a good way to go. And so this isn't a very well-formulated thought, but I'm not sure in the end whether, and this goes back to the first question, frankly, about whether the idea of dignity and the role it might play in voting rights law today should be limited to the notion of the Constitution requires dignity in this context, and hence these voters are denied. I think we could understand it in a more malleable way, that it might be infringed, or an interest might be infringed, even if we wouldn't ground it firmly that every one of these claims needs to be, that a long line is a constitutional violation, although I'm open